Swayam Prabha. Digital India. Educated India.
Welcome back to the course of Law of Torts, Consumer Protection and Motor Vehicles. We are in the lecture number 14, and in this lecture we will continue our discussion from the previous lecture on the same topic, which is defamation. And in this lecture our main focus will be defamation of public officials. That means defamation of people who are in the higher governmental positions or who are politically or in government sphere working in senior level positions, and like Prime Minister, President, Leader of Opposition, MLAs, MPs, Ministers, so like that. And in their case, how they can file for defamation, or what kind of if informations or the news items are considered to be published in newspapers, including social celebrities, including public figures. So we will cover that aspect, but also one or two small aspects that are related to defamation law in general, which we could not cover in the previous lecture, we will cover in this lecture at the very outset. The topics that we will cover in this lecture is freedom of press versus defamation of public figures. Second, Reynolds defense. Reynolds defense is a set of parameters that have evolved through the decision in of the House of Lords in England in the case of Reynolds versus Times newspaper, wherein the court has set certain guidelines which newspapers have to follow with reference to publishing news items involving high level public officials or politicians or bureaucrats or even celebrities. To some extent they are involved, and these defenses of Reynolds case are now more or less applicable and available all over the world, and more or less they are guidelines for free media in all democratic setup, especially in common law countries. So, we will discuss this Reynolds defense. Then we will discuss general defense, specific defenses which usually can be taken in case of defamation. So, what are the usual defenses? And finally, we will see if somebody continues or repeatedly commits libel or slander, what is the position. So, before obviously touching the first issue, freedom of speech and defamation of public figures of this lecture, we will just discuss some of the topics which are left from the previous discussion. So, we were discussing in the previous lecture what and when a statement is defamatory. So, we saw that sometime when the statements are made with words which are defamatory per se, they are defamatory. Sometimes the words are innocent, and usually the plaintiff will not succeed unless the plaintiff is able to establish that the statements have some latent meaning. And in that, when words are used with an internal meaning which is to be understood by the plaintiff or those who know him, but prima facie that is what doesn't literally the word means, then that is called the case of innuendo. So, what happens in the case of innuendo? And the other important aspects are that it should be indicative to the plaintiff. Now, it may not directly name the person or indicate him, but there should be sufficient indicators which should help any person who know that the plaintiff personally or well, will be able to understand that this is indicated towards the plaintiff. And also, it would also have a direct causal link with the event and the plaintiff and the surrounding circumstances, then that becomes all defamatory statements. But there is also one aspect. In the very first slide of my previous lecture, I said that an abusive language or abuse directly does not mean always defamatory. Now, one example that I gave was, you go to your director who has not selected you for promotion and in a closed door abuse him. Now, that can be harassment but not defamation, because publication is not made. But even if you make some abusing statement against the director or against the person who is in power, that if is not having any twisted or any defamatory meaning, which is for the purpose of calculatedly done to disrepute him, to injure his business trade occupation, or to bring him in bad light in social or his other space, it is not defamatory. Now, verbal abuse, for example, in Indian law has been categorized usually in two types. Now, in the first type of abusive language, it is said that which are amounting to insultive. So, abusive language which amounts merely to an insult, and an abusive language which is both insulting and defamatory. For example, please forgive me for using these words, just it is to explain. There is no other purpose, and it's clear apologetic, not apology, clearly I am making a disclaimer that these statements are not intended or anything other than purely just giving example. One statement is harami and second word is chamar. The first word will come under the first part, abusive language which amounts to merely insult. But the second word, sorry, not harami, I am very sorry, kamina. The first word is kamina and the second word is chamar. The first word will come under the first category, abusive language which amounts merely to insult. Kamina is usually, we do not have any other meaning associated to it, we just simply, if we want to insult or abuse somebody, we say kamina. But when we use the word chamar, it is not only insulting, it has also some caste connotation, and we want to disrepute him socially if he, with that caste connotation, if he actually belongs to that caste. So, this is an example of abusive language with both insulting and defamatory nature, chamar. And in India, no action will lie for the first type of language. So, if it is a abusive language which amounts merely to an insult, there is going to be no action. But for the second category, when abusive language is both insulting and defamatory, like the one that I gave the example, then action lie even without proof of any special damage. So, this is a distinctive category that in India we have made, and the example of this is in the case of Parvati versus Mannar. It is an old case, 1884 Madras case, and it says that in that case the defendant abused the plaintiff and said that she was not the legally married wife of her husband, but a woman who had been rejected from several places for unchastity. So, chastity of a woman is a big virtue. So, when you question the chastity of a woman and abuse a woman with a chastity issue, then it no more remains within the domain of simple insulting abusive language. It becomes a language which is insulting and defamatory. And when it is used in this context that she is not the married wife of her husband and she is also rejected by many people for this ground. So, it was held that the defendant was liable though no special damage was proved. Now, what was the court trying to contextually protect or promote in terms of reputational wrongs? The point of the decision appears to be the mental distress. Now, sometimes when we use certain words between two verbal, often in roads, we Indians are very funny people. We, know when we drive our vehicles on the road or walking on the road, because of our population, especially in metropolitan cities, small bumps, small jerks, small collisions are but natural and we don't mind it. But at the same time, when it happens, we are also not going to sit back but pass an abusive statement. So, when two persons collide, which they do every day, naturally when stepping in or out of the Rajiv Chowk metro station at 9 o'clock or 5 o'clock, 5 p.m. or 9 a.m. in the Delhi city, they know it is but natural. But still they will abusively make a statement towards each other, each one of them, and they will not even turn around to listen unless there is something, a major thing. So, that is insulting and we are used to it. Kamina, kutta. But the moment somebody says something which is insulting and defamatory, tera baap chor hai, then the person will take it personal, because there is an element of mental distress. In the first category, there is no element of mental distress, but in the second category, when somebody says tera baap chor hai, it causes a mental distress. So, it is not simple abusive word, it is amount to merely an insult, but a mental distress caused by words which are also defamatory and is actionable, and that is why it is actionable, and there is also no proof of special damage required. Now, coming to the last aspect of the points or factors for libel, which is publication. So, publication is necessary. So, communicating defamatory matter to someone other than the person whom it is written is publication in the legal sense. I already said. Publication does not mean that it has to be printed, it has to be published, it has to be circulated. Publication simply means that it is communicated beyond the person against whom the defamatory statement is made to any other person. And it may be his own relative, own friend, own son, own daughter, own mother, own father. And second is the statement sent straight to the person to whom it is written. There is no publication of it. You cannot publish a libel of a man to himself. So, I gave the example, if I write a letter with lot of abusive languages and defamatory statement and send it directly to my boss in a sealed envelope with no question of anybody opening and seeing except my boss, who is intended also the subject of that letter, then there is no defamation. There can be anything else but no defamation. But when that is openly sent without any seal, without written confidential, and I know all those letters will be opened by the personal assistant of my boss, and knowingly also done, then it is defamation, or even it is not knowingly done also, it is defamation, because a communication has happened beyond the person, so the PA. The question is therefore, defendant knows that the letters sent to the plaintiff are usually opened by his clerk, and the defendant sends a libellous letter which is in fact opened by the clerk or the spouse, whether the defendant is liable. Yes, of course, the defendant is liable, but even if this knowledge was not there with the defendant, still he had sent and it was opened by the clerk or the spouse, the result would have been same, the defendant would have been liable. Now, this publication rule has become little controversial with the emergence of the modern electronic media. And it is not that with emergence of modern electronic media this question has come, but it is a question that has even surfaced earlier, but this has become more categorical in the today's e-media's time. Now, in English law it says that each publication is a separate tort. So, when there is each publication is a separate tort, what does this mean? This means that one article was written and published in the journal of IIT Kanpur in 1971. Kanpur newsletter. The students newsletter, that X has plagiarized a portion of his project from some source. Now, when this newsletter was published, X was not present in IIT Kanpur. Newsletters have very detailed circulation, and in 1971 very limited, so maybe 100 or 200 pieces were only published, printed, and thus it remained within these 100 people, nobody had any knowledge. So, it remained within a very small community and not much information went. Even X himself did not even know that such a information had come out. Now, in 2023, X now, who is an acclaimed scientist, has been appointed in the position of Chief Scientific Advisor to the Prime Minister of India. Now, this is a post which was very contested. Many people were in the race, but finally X made it. Now, somehow, somewhere, some person gets hold of this 71 newsletter and he picks up that information about X and publishes that in Times of India. And now that has a market, because X is now not a student of IIT Kanpur, which at that time he was. Now he is an acclaimed scientist plus newly appointed Chief Scientific Advisor of the Prime Minister of India. Now the question is, of course, X has now got into this information and all these things have come up. Now X wants to file a defamatory suit. He will file defamatory suit against whom? this TOI or the IIT Kanpur journal or both, because TOI in newspaper reference to the IIT Kanpur newsletter source. Now, as per English law, each of these publication is to be treated separately. So, each of them are separate tort of defamation. So, the rule assumes that significance while determining the period of limitation for defamation action, each publication being a separate tort furnishes a fresh cause of action and limitation starts to run from the date of last publication. Now, say IIT Kanpur was in 71. Now, what is limitation? I discussed that limitation is that no cause of action is unlimited in this world. Every cause of action has a limited period, and the limited period is the time frame which a statute prescribes, which is the Limitation Act of 1961 and 69, and the Limitation Act in India prescribes that defamation, the maximum period is 3 years, and therefore, 1971 automatically the tort has been discharged. Even if this was a defamation, it has been discharged by limitation. We discussed dischargement of tort, we will discuss, and in the dischargement of tort we will see limitation discharges tort. So, therefore, no cause of action here. Now, because there is no cause of action here, there cannot be any challenge that it is correct or wrong. Now, TOI against whom there is a cause of action, TOI may say, we have not published anything, it was already published, we have republished. Although republication is a separate tort and separate cause of action, but it can say that because that was not challenged, therefore, we believe that it is true, and he is a public official. So, with his case press has more protection. So, this publication rule has been a contesting issue. The rule assumes significance while determining the period of limitation for the defamation action. Each publication being a separate tort furnishes a fresh cause of action and limitation starting from the date of publication. American law, however, follows a single publication rule, meaning each defamatory material gives rise only to one cause of action. So, according to American rule, however, there is no cause of action here, because the cause of action, according to English rule, there is a cause of action against TOI, but according to American rule, there is no cause of action because the TOI's publication was just not a publication but a republication, and hence according to single publication rule, the publication was in 71 and the limitation period is over. So, it has been discharged. So, this had become a question with reference to today's world, when old photographs are put on Facebook, walls, old newses are put up, old cartoons are put up, and many things are done. So, while those are at that point of time may not have alarmed anyone or may not have even alarmed the person who is the victim of the defamatory statement, but now it is going to affect him. So, in Kanwar Bhatt versus Asif Nazir, the Delhi High Court had an occasion to discuss which rule it is better, single or multiple, and Delhi High Court held the single publication rule to be more pragmatic in its application. It is held that the multiple publication rule defeats the very object and the purpose of the law of limitation, which cannot be permitted. However, the court observed that if republication is targeted to reach to a different and larger section, it would create a fresh cause of action. So, the American single publication rule was upheld that when this republication happen, you get a cause of action against them. So, now he can challenge the IIT Kanpur wala article. So, therefore, this with publication, this is a controversial. Now, we will move to the more the topic of this class's discussion, Now, in this very interesting case, Vasant Kumar Birla versus Prakash Jha. Now, Vasant Kumar Birla is the member of the famous industrialist family of this country, Birlas, and Prakash Jha is a film producer, very famous film producer. And in one of his movie, which was in connection to Naxalwad and all these issues, which is usually his most favorite topics in his movie, there was a song that telecasted in the electronic media. The song, according to appellant, would contain libellous comments that would squarely hit the sentiment and injure the reputation of an industrialist family by the surname Birla. So, like as I said, Rajiv Gandhi, gali gali mein shor hai, Rajiv Gandhi chor hai. So, that is not just affecting the reputation of Rajiv Gandhi, it affects the reputation of the entire family, and Rajiv Gandhi comes from such a family. Jawaharlal Nehru, former Prime Minister, Indira Gandhi, former Prime Minister, Rajiv Gandhi himself, former Prime Minister. Okay? His father, Firoz Gandhi, was a former parliamentarian and a very, very respected politician of the country. His wife Sonia Gandhi, his son Rahul Gandhi, Priyanka Gandhi, all are important political personalities of this country, and they can take it up, that it distributes. So, the Birlas came up very heavy, saying that the surname Birla should not be used, because using the surname Birla is a libellous and squarely hit the sentiment and injury and reputation of the industrialist family. Now, in a Bengali movie, I am a Bengali, there was a statement which also brought attention of the court, which said, Dhirubhai ka sapna thero maal apna. Now, Dhirubhai here is Dhirubhai Ambani, and what it meant in the context, the dialogue and the movie, this song was played, that Dhirubhai was having this dream that he will loot all the common and the poor people of this country and become rich through his industrialized policies. So, similarly, this song had similar kind of a connotation against the industrialist families of the country. Among them, one is Birla. So, the Birlas went to the court saying that this should be injuncted, because they injured the reputation of the industrial family. The version would denote that the lyricist of the singer, or the singer as the case may be, or anyone propagating a cause through the said song was under the belief that the families by surname called Birla would cause injury to common man's interest. So, the version of the song was that anyone propagating a cause, so it was propagating a cause through the said song, and the belief that the family by surnames including Birla would cause injury to the common man's interest by doing wrong to them. A surname might be available to many people in this country, or so to say in the universe. Now, court started saying that a surname may be, anybody can have any surname. However, from the judgment and other impugned herein, we would find the learned single judge accepted the view of the appellants that it would refer to the well-known industrialist family. The way it was used and its surrounding circumstances, it is very clear that here the surname Birla was only indicating this well-established Birla families and their members. So, the indigenous industrialists of our countries are equally responsible for building this modern India. Birlas are indigenous industrialists. The contribution of at least two business houses named in the song right from the day of independence cannot be ignored. Tata and Birla, they were named. Mere song cannot prejudice such fact. What I have observed might be my own perception. A particular class of people might not agree. Unless a statement is libellous, scandalous, or any person or a prudent person would think so, would not be available for a legal action. If the plaintiff is able to prove so, the defendant would be entitled to rebut the same by taking plea of justification. So, how it is happen? So, court is saying that libellous scandalous action has to be proved, but the court says that at one side when we have to preserve the interest of these important business families who have contributed to the making of modern India, there is also right to free speech. Although defamation is a ground on which free speech can be restricted and free speech is not absolute, but still the limit drawing is something which is a very difficult task. And this is what has been the debate between the free speech jurisprudence and the defamation context globally. In Indian context, Article 19 of our constitution gives freedom to speak what anyone feels. What is prohibited is he must not say something which is scandalous or directly hurting someone's sentiment. So, you must not say something which is scandalous or directly hurting someone's sentiment. Now, गली गली में शोर है, Rajiv Gandhi चोर है is not a very scandalous statement, because everybody can make out, as argued by many people, that everybody can make out that it is stated about Rajiv Gandhi as a political person. So, Rajiv Gandhi not as a personal person, but it is very difficult because at times that differentiation becomes very blurred, but it is talking about Rajiv Gandhi as a political person, the Prime Minister of the country, not Rajiv Gandhi the individual person, and also directly hurting someone's sentiment. It is not directly hurting someone's sentiment by this way, because it does not say Rajiv Gandhi ka family chor hai, it does not say Rajiv Gandhi's father chor hai, it does not say Rajiv Gandhi's grandfather chor hai. It says गली गली में शोर है, राजीव गांधी चोर है या कांग्रेस पार्टी चोर है and all this. So, it affects his political identity, it affects his political vendetta by other party, this statement, but it may not affect him in person. So, his personal reputation is not affected. So, even then persons aggravated may react in a way we may feel best. So, initiation against the character of his personal life. So, unless it is initiation against the character of the personal life, then restricting free speech will be not very conducive. It will be hurting the interest of democracy. And therefore, fundamental right of free speech or Article 19(1)(a), from where the freedom of press germinates. So, press is fundamentally considered as essentially the necessary instrument in a democratic setup which is responsible for ensuring free speech. It is considered as the most important pillar of democracy, and the power for the freedom of press emerges from the free speech right under Article 19(1)(a), and as has been held by the Honorable Supreme Court in several cases and outside also. So, now the contrasting interest is, this is one side, this is the interest. On the other hand, the contrasting interest is public figures like public officials have an influential role in ordering the society. They have access to mass media communication both to influence the policy and to counter criticism of their views and activities, and a citizen has a legitimate and substantial interest in the conduct of such person. So, the moment a person becomes more than his limited self, he assumes a public figure, a public person of public importance, and he commands a lot of influential role in the ordering of the society, and he has access to control the media and influence the policy. Therefore, people have a right to know whom they choose as their leader of masses like this. and continue to know in a sustained manner that whether they have made a right choice or not a right choice. And in this regard, press plays a very important role. So, the moment a controversial statement or a controversial news is brought to public, it is affecting the reputation of that individual, no doubt about it. The day when the most powerful man in the earth, the President of America, Bill Clinton, was charged by newspapers and media all over the world for sexually assaulting an intern in his office, everybody was taken aback. And of course, this was a charge against his reputation. And being the most powerful man, he had made every attempt to cover it. But it was the free speech jurisprudence that prevailed, and the freedom of press and independent press of America, that this news ultimately surfaced. And now came the question that how citizens will take it up. And Clinton had to seek a public apology and face a motion for his termination of presidency. So, if this important right of the press is cut, then how are these people going to be tamed? If they are morally correct, then good. If they are not morally correct, then they will turn these offices into such centers of power which will be anti-democratic. So, the court has to always do this fine-tuning balance. And in this regard, I will refer to 3 cases over a period of 1964 to 1999, where the courts have been squarely placed with this debate in 3 different countries, each very important in the common law perspective as well as from the perspective of the contemporary development of law relating to free speech versus protection of defamation of public officials. The first case is from United States, which was decided by the Supreme Court of United States of America in 1964. The name of the case is New York Times versus Sullivan. The facts of this case was that an advertisement was carried in the Times newspaper by the supporters of the civil rights movement, who were followers of Martin Luther King, regarding some incident that happened in a meeting that was conducted by Martin Luther King, which was supposed to be a simple, peaceful civil disobedience movement, yet there was lot of violence that was ushered upon the peaceful protesters from the side of the police administration, especially targeting on the racial minority, and that had some backlashes. But very interestingly, the news item carried a lot of wrong informations also. The informations were definitely not accurate. There are a lot of mistakes in dates, figures, facts, names, and all this made the police commissioner of the particular city which was in context to file a defamation suit against the Times newspaper and asking for $50,000 and compensation. Now, the trial court, after looking at the facts and the law in context, decided in favor of the plaintiff and awarded the suit. This was challenged in the Court of Appeals first and then to the American Supreme Court. Now, American Supreme Court said that when it comes to high level public officials, the context of defamation rule is not just simply those three conditions which are established for judging defamation for any person. That is, it should not be false, it should be published, and it should be defamatory. Now, this is good enough for any public person, but not for public officials of high rank holders. In their case, there has to be an additional ground to restrain or to hold the information defamatory, that is, there has to be a malice in the part of the newspaper. So, newspaper had a malice, and how do you prove this malice? You prove this malice is that it is an inaccurate newspaper and it was a news item which was completely false or baseless, and it was also published with utter recklessness and disregard for any legal norm. Unless this is proved, restrainment of publication of such news or considering is defamatory is out of question. And on this ground, it reversed the decision of the Court of Appeals. And the observation of the American Supreme Court was the right to freedom of speech has also been interpreted in the United States a bar to public officials from recovering damages for a defamatory falsehood relating to his official conduct unless the statement was made with knowledge that it was false and reckless disregard of whether it was true or false. So, these two additional conditions have to be also fulfilled apart from the general condition, because they are public officials and right to freedom of speech protects the right to freedom of press to dig out such informations, because otherwise democracy will be robbed and people will be left with no information. In Rajagopal was a state of Tamil Nadu, Indian Supreme Court had a similar question in 1994 where an autobiography of a murder victim was restrained by high police officials, saying that what is going to be published is all false statements, because he had informed in the autobiography about his engagement with several senior big government and private officials. When the publishing house went to Supreme Court, the Supreme Court held the above view has also been accepted in India, the Sullivan's view. It would be enough for the defendant to prove that he acted after reasonable verification of the facts and that it is not necessary for him to prove that what he has written is true. So, entire truth of it is not necessary, but he has made necessary verification, that is, it is not recklessly done. And the last is the Reynolds case, which involved the former Prime Minister of Ireland, Reynolds, and the Sunday Times of Times newspaper, where allegations contained in the report against Reynolds were found. The trial judge held that defence qualified privilege was not established and awarded nominal damages. The Court of Appeal held that the publisher would not be able to rely on the defence of qualified privilege. The publisher appealed to House of Lords, the highest court. All the three judgments that I am quoting are from the highest court of these three countries, Supreme Court of US, Indian Supreme Court, and this is the House of Lords. And the House of Lords did not accept the submission to recognize this new category of qualified privilege. House unanimously agreed that the traditional ambit of qualified privilege should be extended. But what is necessary is a responsible journalism. And what is the responsible journalism or the steps to be taken? The court gave certain series of defences, a certain series of steps to be followed, which is popularly called 10 steps, which are popularly called as the Reynolds defence. So, responsible journalism in such kind of sensitive matters. And what are these defenses or what are the steps? First, seriousness of the allegation has to be ascertained. More serious the charge, more the public misinformed and individual harmed if the allegation is not true. So, the seriousness of the allegation has to be determined. More serious is the charge, of course, there is more chance of misinformed and individual harm. So, allegation has to be accordingly verified. The nature of the information, the extent to which subject matter is a matter of public concern, that has to be determined. If it does not concern the public, just a masala news, it should not be usually treated in priority. Third, the source of the information. Some informants have direct knowledge of events, some have their own access to grind or being paid for their stories. So, you should have a clear, you may not disclose it, but you should have a clear understanding of source of the information. The steps taken to verify the information. What are the steps that you have taken to verify the information? The status of the information, the allegation may have already been the subject of an investigation which commands respect. So, if the matter is already under investigation, then do not dug into it anymore, because it is a sub judice matter. If it is a sub judice matter, then media or press should refrain from getting involved in it. Then the urgency of the matter. How urgent is the matter? News is often a perishable commodity. So, if it is urgent, then with that urgency, lesser verification may justify. So, today you come to know suddenly as a media person that X, who is Prime Minister of X country, has been bribed, and you have to publish the news tomorrow. So, within that span of 8 to 9 hours, whatever possible verification of the highest order due diligence you can do, you have to do it. So, urgency is important because news is perishable. So, the value of that news today may not have tomorrow. Whether comment was sought from the plaintiff, he may have information others do not possess or have not disclosed. An approach to the plaintiff will not always be necessary. So, usually the plaintiff has to be approached. He has to be called and he has to be asked that this is an information I have which is primarily against you. Now, he may not answer, that is fine, but you have to take the step. But not always this approaching is necessary. Urgency is one ground where it can be left out, but otherwise it has to be taken up. Whether the article contained the gist of the plaintiff's side of the story. So, if the plaintiff was also approached and he has given also part of his side of the story, the article should also put that part also. Article cannot be a one-sided report. So, it should put also the plaintiff side story. The tone of the article is important. A newspaper can raise queries or call for an investigation. It need not adopt allegation as statement of fact. So, the tone of the article has to be sublime. The newspaper has for public interest right to raise queries, may also ask or call for investigation, but newspaper has no right to demand you please resign and go to Banvas, or you please remove yourself from this position. These are individuals who can make such statements or facts or allegations, but newspapers cannot make such statements. So, tone is important. And lastly, the circumstances of publication including the timing. There has to be a clear understanding about the circumstances of the publication and the timing requirement. Now, coming to the next topic, which is what are the defenses. Now Reynolds defense, you can understand, it's used Reynolds defense, but it is actually not the defense in that way. It lays down some best good practices or best practices for modern investigative journalism when it involves information regarding such kind of sensitive matters which involves high government officials. Now in that case, all courts of highest order has ruled out that media has less right and defamation will be prioritized. Everywhere it is the contrary view, but everywhere from Sullivan to Rajagopal to Reynolds, a responsive journalistic role has been prescribed. And in Sullivan it was said that the journalist has to be not reckless or malicious. Same was the view in Rajagopal, and in Reynolds they have now devised this into 10 clear proposition of practice, and this has been adopted. But what I am going to discuss now is defenses, that what justification that can be given for a defamatory statement. Now when it comes to defamation, the most and the best justification is truth, because the first element of defamation is falsity. If you can prove the statement is true, then there is no further issue. Second, fair and bona fide comment. There was a public interest that was required and there was no injury. There may have some loss but no injury. So damna sine injuria. So fair and bona fide comment. And the third one is called privilege. So certain people enjoy certain privileges. Even making a defamatory statement, they can still excuse, because if they come within the privilege. For example, in the parliament, if a parliamentarian calls another parliamentarian chore, it falls within the privilege of absolute category. So parliament statements are privileged communication of absolute category. So there can be no individual or professional dispensation of reputation or harm to reputation or a defamatory suit in a comment made against each other in the parliament. Similarly, press, who has the right to ensure information in a democratic society, enjoys some category of privilege, but this privilege is not absolute like the parliamentarian. It is called qualified privilege. And what is that qualified privilege? It has to take necessary and reasonable care. And the Reynolds defense is an example of how do you use your privilege, how do you benefit from your privilege without discomforting or without being affected. So justification by truth. So truth of a defamatory word is a complete defense against any action of libel or slander, as I said. Fair and bona fide comment on a matter of public interest is not libel. The minister is inactive. This is a fair and bona fide comment. Similarly, privileges, and there are two categories of privileges, absolute and qualified. And these are the defenses which can be availed in addition to the general defenses which are already discussed earlier. Finally, the last proposition is repetition of libel and slander. It is no defense to an action for libel or slander that the defendant published it by way of repetition or hearsay. So as I said, that IIT Kanpur wala story. 1971 IIT Kanpur journal, I saw or I heard, I took it and I have republished it. So, I am not under defamation. If that is correct, I have just repeated it, but there is no defense of that. Every repetition of defamatory word is a new publication and a distinct cause of action is created. So, you are not safe. That is why single cause of action, the American rule, they are saying that single cause of action. And the originator will be liable for the damage resulting from the repetition, where the originator authorized or intended the repetition. Now, for example, if IIT Kanpur, the limitation period is over, but it can still be held liable if any of the three conditions are satisfied. One, where the originator authorizes or intended the repetition, where the repetition was natural and probable consequence of his act, and where there was a moral obligation on the person in whose presence the slander was uttered to not repeat it, yet he did it. So, in all these cases, the originator will be held liable, and repetition on basis of somebody's knowledge or saying somewhere is not a defense. So, with this I end my discussion on defamation. In the next we will discuss the remedies available in tort, and I am looking forward to all of you joining me in the next class. For today, thank you for joining the class. I hope you have enjoyed the discussion that we had on this important area of defamation, and looking forward towards the next lecture. Thank you very much.